Hello, and welcome to the second of our four-part LEAP training for public librarians, brought to you by the Law Library of Louisiana and the Access to Justice Department of the Louisiana State Bar Association. My name is Sarah Pick, and I am Head of Public Services at the Law Library. LEAP stands for Legal Education and Assistance Program and is a collaborative effort between the Louisiana State Bar Association, the statewide Association for all Louisiana lawyers, the Law Library of Louisiana, the state's law library located in New Orleans but serving the entire state, the Louisiana Library Association, the statewide association for all librarians in Louisiana, as well as other legal aid and legal technology partners. LEAP's goal is to provide training and resources to empower public librarians to serve the legal reference needs of their patrons. In this video, I will provide information on legal reference, including do's and don'ts pointer tips, and discuss the unauthorized practice of law in detail. The first part of this video series, presented by Stephanie Bowe from the Access to Justice Department, discusses Louisiana's access to justice issues. The third part, presented by me, provides an overview of the various reliable legal information resources, many of them free, available for you and your patrons. And the fourth part, also presented by Stephanie, is an in-depth dive into the various low-cost or free services the Louisiana State Bar Association offers or helps facilitate for patrons who need a little more than legal information websites and books and could benefit from speaking with an attorney. A common refrain many of us may have heard that a patron saw Judge Judy and perhaps thought that they too could just make their argument in front of a judge and receive a ruling. Unfortunately, it is not so simple. Many people have a false understanding of what the law is and how it works because of television. Even reality TV is still TV. It is our job as librarians to help educate them and guide them to what is true and authoritative. Unfortunately for our patrons, though, these are the only laws written in stone. Everything else in the law can be prefaced with, "It depends." Though patrons may come to you wanting easy answers, it is never so simple. Even so-called black-letter law where there are bright lines, can be squishy. There's a reason two lawyers argue opposite sides of every case. This is part of what makes legal reference especially challenging for librarians. Before we dive into legal reference skills, it helps to have an overview of the law and how it is structured. When considering the law in the United States, we always begin with the Constitution, whether that is the federal or state constitution. A constitution is a blueprint for the construction of a government. It is the fundamental basis for structuring our government and law. Why everything is designed the way that it is derives directly from our constitutions. Our three branches of government are created by our constitutions. Though it is useful to think of the government as three branches, legislative, executive, and judicial, it is not a complete picture. We also have municipal authorities and quasi-governmental agencies, but three branches is a good start. The three branches have different responsibilities. Put simply, the legislative branch creates the laws, the executive branch implements the laws, and the judicial branch interprets the laws. You can find the laws the Louisiana legislature creates chronologically in the acts and by topic in the statutes. Similarly, Louisiana administrative regulations, which come from the administrative agencies and are part of the executive branch, are found chronologically in the register and by topic in the administrative code. There are similar compilations found in the federal branches. The judicial branch is divided into trial level and appellate level courts. Trial courts make orders and rule on motions, but the decisions made by the trial court are binding only on the parties in that case. The decisions by trial courts are not typically published, but you can sometimes retrieve them from databases or directly from the clerks at the court. Appellate courts write opinions which are published, both in print books and in electronic databases, and apply to their entire jurisdiction. You may hear about primary sources of law and secondary sources of law. This is a little misleading. Primary sources are the actual law. They are the laws passed by the legislature, the regulations promulgated by the executive, or the opinions written by the courts. Secondary sources are the explainers of that primary law. They include legal dictionaries and encyclopedias, and treatises, which are like textbooks about the law. Now that we've covered the basics of law, let's talk about legal reference. Legal reference really isn't different from any other type of reference. It may seem trickier because often people search for legal information when they are in the midst of a crisis. But just as you would not offer a diagnosis of a patron's medical condition, you also would not attempt to solve a legal issue. When a patron comes to you with a legal question, you may think, "How can I help them? I don't work in a law library." Or, "Oh no, a legal question, but what if I accidentally provide legal advice?" We are here to say there is quite a lot you can do in whatever library you are in without providing legal advice. The American Library Association's guidelines on providing reference services are just as applicable to legal reference as to any other type of question you may get. You still want to be approachable and friendly, show interest in what they are saying, listen, but also ask inquiring questions, searching with them for the answers, and following up to make sure they found what they needed. It's important to remember that your role is as navigator. You are not there to solve their legal problem. You are there to help them find a resolution for themselves. And you do this by assisting them in locating reliable and authoritative legal information online, in databases, and in books. You show them the steps to locate the information, provide instruction on how to use the resources, and refer the patron to other sources and services. There are some challenges that come up more frequently in legal reference than in other types of reference. These challenges can make providing the best service harder. Patrons with legal questions may often be in crisis, but your best response is to remain calm and approach them with the same friendliness and responsiveness you would for any patron. Maintain boundaries, but remain friendly, open, and sympathetic. Most importantly, remember, even if you disagree with a patron's course of action, they still deserve judgment-free help with no opinions from us on their choices. Often, our patrons have been told what to do by people in positions of authority their whole lives. As librarians, we have the privilege to empower them to make their own choices, even if we disagree with that choice. Unauthorized practice of law, or UPL, is always the elephant in the room when we talk about librarians answering legal questions from the public. However, UPL is specifically where the state prosecutes someone for violating the restrictions on who can practice law or holding themselves out as a legal expert in order to defraud people. Professional liability is where a patron would sue someone because they relied on their supposed expert advice to their detriment. The reality is that librarians have never actually been prosecuted for UPL that anyone knows of, nor are there reported cases of professional liability. However, as librarians, we do have real ethical concerns that we should be aware of. We must provide the best possible service without crossing that line into providing advice, because that is simply not our role. A best practice tip to help avoid UPL and avoid any ethical quandaries is to remember to hold yourself out as an expert in finding information, not an expert on the information itself. Now for some legal reference interview do's. We will go over some of these principles and resources in more detail later in the presentation. Do promote open access to legal information. Do provide resources on court procedure, court rules, and other law. Do provide access to legal forms and instructions. Do direct patrons to legal treatises, legal dictionaries, or legal encyclopedias for explanations. Do provide options, resources, and referrals. Do allow patrons to come to their own conclusions. And remember, suggesting someone should seek legal advice is not giving legal advice. And now let's cover some legal reference interview don'ts. Don't be invested in the case outcome. Don't guess how a judge will rule. Don't fill out legal forms for your patrons or give advice on how to fill them out. Don't interpret or explain the law. Don't identify a specific law for the patron's problem for them. Don't advise a patron about a legal course of action. Don't recommend a specific lawyer. It is okay to recommend specific agencies and organizations, which we will talk about more in the next section of this training. What form can I use is one of the most common legal reference questions from patrons. Forms present their own set of challenges, so let's cover do's and don'ts specifically for forms. Do inform patrons about the existence of court-approved forms. Do show patrons how to navigate the websites that contain those court-approved forms. Do inform patrons of any known legal service groups that will help them complete the forms. We will discuss these groups in greater detail in the fourth and last section of the training. Do recommend form books for examples of legal forms. This can include contacting a law library that has a larger collection of such books. Do suggest books on specific legal topics that may include forms. Again, contacting a law library if you need to obtain a book not in your collection. Do show patrons how to use the index and table of contents for a form book. Do point out primary and secondary sources, such as annotated codes, legal encyclopedias, and treatises that may reference relevant forms. Don't prepare legal documents or complete forms for patrons. Don't advise patrons on how to fill out forms. That includes patrons who just want you to look it over for me. Don't interpret language in a form for a patron. Don't suggest that a patron use a particular form. Sometimes we may not realize that our intonations may convey a meaning we don't intend. So, for legal definitions, we recommend that you do direct patrons to a legal dictionary and show them how to find the words, but that you don't read the definitions to them. For example, if a patron calls on the phone, avoid reading them the definition and instead send it to them via email or mail. You may place emphasis on certain words that connote significance you did not intend to the patron. Increasing uncertainty goes against our instinct as librarians to want to provide the answer. But sometimes the best thing we can do for our patrons with legal reference questions, especially for those who are representing themselves in court, is to increase uncertainty. We really need them to understand there are multiple possible paths and multiple possible outcomes once they are in court. Increasing their uncertainty is actually helping them by making certain they understand that court is uncertain. Sometimes they really may need to consult a lawyer. We will cover free and low-cost ways for them to do so in the fourth and last section of the training. The first step in a reference interview is identifying the type of patron. Are they self-represented, also called pro se, meaning are they actually in court now or preparing to file a court case? Or are they students or teachers who are researching a legal question? Or perhaps they're just curious, maybe they heard about a law in the news and want to know more. How you handle each of these patrons differs. With self-represented patrons who are already in court or preparing to go to court, we want to try as hard as we can to refer them to an attorney and be very cautious about that line between legal information and legal advice. With academic type questions, we don't typically need to refer them to an attorney. Next, we want to identify the type of question. Are they looking for the law on a particular topic? If so, we may want to start them with secondary sources, dictionaries, encyclopedias, treatises. Or are they looking for a known item, such as a case or statute? Then we want to look to primary sources. They may have a citation and just need help finding it. If you aren't sure what the citation is, call us at the Law Library. We are happy to help. You'll always want to try and determine the jurisdiction, as that will tell you what resources they may need. If they are asking about a statute, they may mean the U.S. Code or the state revised statutes. Dates can also be important. If they are looking for an older law, have them call us at the Law Library, as we have copies of older versions of laws here, which are not available online. Listen for the legal words and phrases or names. These can help guide you. Often, patrons know the name of a party in a case and what it is generally about. You can use that to help them find the case they are looking for. As in all reference, ask lots of questions, but try not to get bogged down in the details. They may want to tell you every detail of their legal saga, and listen as much as you can, but also try and keep them on track by repeating to them what you think they are looking for. Look also for clues in materials the patron already has. They may have printouts of cases or statutes. Some handy phrases to help guide your interactions with patrons who may be trying to push you for advice. I'm a librarian, not a lawyer. My training isn't helping people find information, so I can't explain the law for you. I can point you to helpful information, but I can't apply it to your situation. Here's a source for legal forms, but you should check the instructions to see if they apply to your specific case. And last but not least, for those patrons who really can't stop pressing, I'm forbidden by law from giving my opinion, including what I would do in your situation. Though we know, as we covered earlier, it is highly unlikely you would ever be prosecuted for UPL. Your patron doesn't need to know that. You can use the UPL law as a shield against the patrons who really can't stop pressing for advice. Let them know, this is illegal and I cannot help you in this way, but I can help you find information. Thank you for watching Part 2 of the LEAP training series, Legal Reference and Unauthorized Practice of Law. If you have any questions, don't hesitate to contact us at 504-310-2400 or toll-free in Louisiana at 800-820-3038 or email us at library@lasc.org. Our website is lasc.libguides.com. You can also reach me, Sarah Pick, directly at svpic@lasc.org. Please check out the other videos in this series brought to you by LEAP, Legal Education and Assistance Program.